My name's Deputy Inspector General of Police, Dr. Shehu, PSC. To talk about PRAWA, Prisoners Rehabilitation and Welfare Action. We have a very, very good rapport, good understanding, and good synergy between the police and PRAWA for many years. It is an institution that concerns primarily on respect of dignity and human rights, which the police are supposed to be part of it. And also capacity building to the police to enable them to perform effectively and efficiently in conjunction with the fundamental respect to the fundamental human rights as enshrined into the Nigerian constitutions of 1999. It's very, very beneficial, and at the same time in building capacity and enabling the police officers to perform credibly when they go out to discharge their duties. The police is an organization that deals with all kinds of human beings. When they come across a police officer, they deserve to be respected by police in ensuring not only their security and safety, but also in respecting their dignity and human rights. So in a nutshell, the training and retraining we are getting from the PRAWA is to enable us have police that will function and discharge their duties in a most standard and acceptable manner by members of the public. At this juncture, I want to say kudos. Welcome to the Nigeria Police Force online training.
Welcome. This is still online human rights training for Nigerian Police Force. Today, we are going to take the topic, terrorism and human rights. The lesson objective of this topic is to create awareness on the human rights standards required in the processing of terrorism suspects. And the expected outcome is that at the end of the training, you will be able to exhibit greater knowledge of the guidelines for good practices in addressing issues of terrorism and treatment of terrorism suspects. Introduction to terrorism and human rights. Terrorism, despite being a global phenomenon, has remained a subject matter that resisted social scientists' efforts in preferring an acceptable definition. The rise of the dreaded Islamic group in Nigeria, known as Boko Haram, changed the dynamics of terrorism in Nigeria. So what we see is that different countries, different nations prefer different definitions to terrorism. Amongst the activities of other persons and groups, that is the issue of Boko Haram with other activities, like the activities of the militants and the rest of them and the other groups, propelled the Nigerian government to enact the Terrorism Prevention Act of 2011. This piece of legislation was amended in 2013 as Terrorism Prevention Amendment Act of 2013. As we go into the discussion, we will understand the reason for this amendment. It is not unconnected to issues around the protection of human rights. Definition of terrorism and terrorists. Terrorism is defined as an act which is deliberately done with malice aforethought and which may seriously harm or damage a country or an international organization. I want you to pick those two words, malice aforethought. You will understand the reason for this later. It is also intended or can reasonably be regarded as having been intended to unduly compel a government or international organization to perform or abstain from performing any act. You see, from your little experience of terrorism and the activities of terrorists, you will understand that what they do is highly violent. In our criminal code, penal code, and other statutes, we equally have provisions criminalizing violent acts. But you see the difference between the definition of these acts in these other laws and in the Terrorism Act. You will see that in the fact of that issue around malice aforethought and the idea of intimidating a nation. Terrorists seriously also intimidate a population. They intend also to destabilize or destroy the fundamental political, constitutional, or otherwise influence such a government or international organization by intimidation or coercion. Of course, you were all here in Nigeria when Boko Haram was threatening fire and brimstone. When they wanted to attack, they first of all attacked the force headquarters. They went to UN building. What were they doing? They wanted to intimidate the government of Nigeria, the United Nations. Wherever they feel they have conquered, they hoist their own flag. That is intimidating a country. It's not an ordinary crime. Terrorism also involves or causes, as the case may be, an attack upon a person's life, which may cause serious bodily harm or death, kidnapping of a person. You were there when the Chibok girls and Dapichi girls were abducted. These are examples of acts of terrorism. But in their case, you see the difference between what they were doing and what kidnappers do today. Kidnappers will pick somebody. They are not videoing anything. They don't want you to know them. They just want your money. But terrorists want to make everybody afraid, the citizens afraid. People will stop sending their children to school. That's why when Chibok girls were kidnapped, they videoed, showed Nigerians. That was intimidation. Now, they equally target destruction to a government or public facility, a transport system, an infrastructure facility, including an information system. You equally remember what happened when the Niger Delta militants were bombing the gas lines, preventing the supply of electricity. So terrorism involves serious, violent acts, but in different way, done with serious malice aforethought. They have thought it out and they intend to actually intimidate and coerce a government to do what the government should not ordinarily do. That is why you equally see that some governments say they can never negotiate with terrorists. Terrorism is also an act or omission in or outside Nigeria which constitutes an offense within the scope of a counter-terrorism protocols and conventions duly ratified by Nigeria. Look at Section 1(2) of the Terrorism Act 2011. So most of the discussions we are going to have are discussions that will relate to how you should apply human rights in your counter-terrorism mechanisms. Now, the Terrorism Prevention Amendment Act of 2013 included Nigerian Armed Forces and Nigerian Correctional Service as law enforcement / security agencies. And notwithstanding the provision of the Terrorism Prevention Amendment Act of 2013 that expanded the institutions charged with the responsibility of investigating terrorism, the police stands as the traditional driver of ensuring internal security of Nigeria. That goes with the provision of Section 4 of the Police Act. Now, what are we trying to say? We are trying to say that no matter how you look at it, the police is an institution that should be playing great role in the counter-terrorism mechanism of this country. The 2013 Act is an expansion on the provisions of the Terrorism Prevention Act of 2011. So many issues were addressed in this 2013 Act. The meaning of who is a terrorist is equally expanded to include persons that sponsor terrorism acts, to include even those that provide little services to terrorists, like those that supply them with food, fuel, and the rest of them. Now, is it everybody that can be called a terrorist? These are some of the mechanisms that have been put in the Act to ensure that people are safeguarded, that the human rights of persons is, protected. Because if it is left like that, anybody can wake up one morning to say any other person or organization is a terrorist or a terrorist group. So it is provided that a person may be declared a suspected international terrorist on recommendation of the Attorney General, number 1, Inspector General of the Police, number 2, National Security Advisor, number 3, or the coordinator appointed by the President, if the President reasonably suspects that the person is or has been involved in the commission, preparation, or instigation of acts of international terrorism. Number 2, or is a member of or belongs to an international terrorist group or recognized as such under the provisions of this Act. A person can also be reasonably suspected to be a terrorist of international repute if such a person is listed as a person involved in terrorist acts in any resolution of the United Nations Security Council. With respect to the declaration of a group as an international terrorist group, one of the applicable conditions is if the group is suspected to be in control or influence of persons outside Nigeria, and the President reasonably suspects that it is involved in the commission, preparation, or instigation of acts of international terrorism. It is important to note that acts such as arranging, managing, or assisting in arranging or attending meeting of the proscribed terrorist organization and soliciting or rendering of support to a proscribed terrorist organization or harboring a terrorist is also punishable by law to imprisonment for maximum term of 10 years. Assessing the human rights safeguards as contained in the Act. One thing we would love you to understand as police officers is the fact that a terrorist equally has human rights. Don't get it mixed up. That someone is a terrorist does not mean that the person still does not have human rights. What happened is that that person has committed a crime, and should be processed according to the law, just like other criminals are processed or suspects. And remember, when you pick up a suspected terrorist, such person still is deemed innocent until proven guilty by a court of competent jurisdiction. So don't go ahead and pass judgment on a suspect of terrorism. What he may be denied may be the right to freedom of movement. He still has other human rights until the court determines his case and finds him either guilty or innocent. So we have to be very careful. Don't deny terrorist suspects of their rights. So, having said that terrorist suspect is equally deemed innocent until proven guilty, and that his human rights should equally be accorded to him, we now expect that in handling such suspects, you as a police officer must ensure that due process is followed and that no violations of the person's rights or infringement on his rights, no matter how, is made in the implementation of the act. So the following safeguards have been introduced in the Terrorism Amendment Act. First of all, in declaring an organization a terrorist organization, the Act provides that the judge in chamber may, on an application by, number one, the Attorney General, number two, National Security Advisor, number three, Inspector General of Police, on the approval of the President, declare an entity to be a proscribed organization, and the notice should be published in official gazette so that we don't go tagging our enemies terrorist groups. A judge in chamber making such an order, the order shall only be made after the following has been met. Number one, upon the application of the Attorney General or the enlisted persons above. That is what the law says. Without going through this process and getting an organization proscribed and declaring it and gazetting that, you should not treat any organization as a terrorist organization. The Act also provides that the President may declare a person a terrorist or a group a terrorist group on the recommendation of the National Security Advisor, Inspector General of Police, or National Coordinator appointed by the President. Still saying the same thing. Now, ensuring that an organization declared as terrorist organization and that the declaration so made is made a public knowledge. One thing is declaring an organization terrorist organization. Another thing is communicating this information to the people. That's why the order must be made by the judge. And as soon as the judge makes that order, it should be published in the following: official gazette, 2 national newspapers, other places as the judge in chambers may specify. The reason for this is it will prevent the secret declaration of an organization as a terrorist organization and thus provide opportunity for any person or organization to challenge such declaration if they so wish. Protection of lawful opposition groups from being labeled terrorist organizations. You know this is very, very important. If not, enemy camps in politics will automatically become terrorist groups. As stated under Section 13 of the Terrorism Act of 2011, an act which disrupts service but is committed in pursuance of a protest or demonstration or stoppage of work is not a terrorist act within the meaning of the definition of terrorism given under the Terrorism Act, provided the act is not intended to result in any harm referred to in section 12B II or IV of the Act. You are now given the assignment to go and check up these sections. Read through, digest that to get the necessary information to equip yourself to do your work. Now, there should be non-retrospective application of the Act. It is a defense for a person charged under subsection 3 of this section to prove that the organization had not been declared or a proscribed organization at the time the person charged became or began to profess to be a member of the organization. What that simply means is that prior to declaring Boko Haram a terrorist group, persons that engaged in activities with Boko Haram at that time, prior to that declaration, can never be arrested to say, in 2008, you were this or that with Boko Haram, so you're a terrorist. No, that would be making the law apply retrospectively against such persons. So this provision is equally, that's section 4, is equally a kind of protection for persons and their human rights. No person shall be held guilty of a criminal offense on account of any act or omission that did not at the time it took place constitute such an offense, and no penalty shall be imposed for any criminal offense heavier than the penalty in force at the time the offense was committed. This is an explanation of what we have just said, and that is section 36(8) of the 1999 Constitution as amended. Rights of suspected terrorists. Terrorists, as I have repeatedly said here, have rights. Of course, by virtue of section 35 of the Constitution, they are equally innocent until proven guilty. They are still suspects. Persons charged as suspected terrorists also have rights, which need to be respected even in the course of determining their guilt and bringing perpetrators to justice. These rights include the following: right to have access to medical doctor and legal counsel. In the 2011 Act, it was provided that these persons will access medical doctor of the facility or the agency of government handling them or their legal counsel. But this anomaly, this human rights denial was corrected in the 2013 Act. Right to be presumed innocent until proven guilty. Section 36(5) of the 1999 Constitution. That is the one that talks about presumption of innocence. Now, right to be promptly arraigned in court. Any person arrested and detained, if not on bail, shall be brought before a court within a reasonable time. What this provision is saying is that as much as possible, carry out your investigation and make whoever is a terrorist suspect appear before the court. To ensure that the public is effectively protected from terrorist activities, while ensuring the observance of human rights, every effort should be made to follow due process of the law and to depend more on covert intelligence gathering and proactive responses rather than expression of brute force and retroactive responses. I hope you understood that. As police officers, you should do your intelligence. Intelligence gathering is very, very important in the fight against terrorism. It's not every point, at every time, that terrorists should move ahead of you. And when they have committed the act, you now start reacting. You shouldn't be reactionary. You should be proactive. So what we are saying in effect is that you have duty to perform as police officers regarding counter-terrorism engagement of the country. And that the critical things you must note is that you should be on top of your game in terms of the legal framework for the fight against terrorism. You must know what the law says. You must know who a terrorist is and what constitutes terrorism acts. Then you must have the 2011 Act at the tip of your fingers and the 2013 Amendment Act. Please also check especially sections 35 and 36 of the Constitution. What do they have to say? And above all, note that terrorism is equally a criminal act, and that in processing terrorist suspects, you must accord them the human rights they deserve. You know the right that can be denied. Example, in terms of remanding them, the right to movement, freedom of movement, but they still have all their other human rights intact until a declaration is made by a court of competent jurisdiction. Do not give terrorists reason to continue in their acts in the argument that the state is not better than them. When you keep torturing persons, suspects, they will portray you as even worse than they that are the terrorists. And this does not do good to the image of the country, neither does it do any good to the counter-terrorism engagement of this country. We want to succeed and bring this scourge to an end. Thank you.